Mr. Bond, I must commend you. You have far exceeded even the stories of your previous exploits. And this time, you actually almost got away with your rather perfect operation. However, most unfortunately, our security forces had recovered your confidential weapon system. Too bad, Mr. Bond. This job is to be yours. You are a very smart man, Professor. Indeed, Mr. Bond. I went to Knox School. A very special Knox School, where we had learned all about novel coronaviruses. And this one has been acknowledged in, shall we say, the street circles to possess an etiology rather quite singular. Attention, all units. We are detecting an intruder in Sector 6. Break. Bogey identified as code number 21220. Break. Dispatch all available units to interdict and regulate the situation. Break. Please report back when the situation is neutralized. Over.
Control, this is Echo 5. The description over.
Not at this time, Echo 5. Break. We need your forces to conduct a movement to contact in Sector 6 and provide a visual report back to Control. Over.
Yes, Roger, Control. We are proceeding to the objective.
Help. Intruder, halt your activities now. Security forces are responding to your sector. Resistance is futile. Please surrender, or they shall be compelled to take appropriate actions with extreme discretion. This is your final warning. The date time group was 16:23 hours Eastern Standard Time, or 4:23 p.m. on March 23rd, 2021. The White House is one of the most secure facilities in the entire world. However, one email would shatter that sense of security 6 hours later at 22:50 hours or 10 minutes to 11 civilian time. This was just a simple email with a letter attachment and providing a simple request for agency records that had been received at the White House near the close of the business day on a Tuesday. It could have waited until the next day for a response, but nearly an hour before midnight, according to the official records and communications, Dion Hardy, the FOIA liaison for the Office of Management and Budget, OMB, had composed and transmitted an email back to the requester, assigning this request the tracking number of OMB FOIA number 21220. Ms. Hardy was hardly a novice and had managed to retain her position even after the transition of the Biden administration, succeeding the first Trump administration. In January 2020, she had in fact been involved in a White House controversy that had been stirred after 20 emails regarding frozen Ukrainian military aid that the New York Times had sought during their first attempt to impeach the president. Then she had asserted a claim of executive privilege to justify the withholding of those 20 emails, justifying the withholding as having been permitted under law to protect both deliberative and presidential communications, the disclosure of which would inhibit the frank and candid exchange of view that is necessary for effective government decision-making. These had been emails that had been exchanged between Robert Blair, an assistant to the president, and senior advisor to the acting chief of staff, Mick Mulvaney, in addition to Mike Duffy, the senior official at OMB responsible for overseeing disbursement of funds for national security. Yet these are high-level officials in the highest echelons of Washington, and and its political structure, and drawing a close nexus to international relations with the Ukraine. And so perhaps the first question is why, near the midnight hour, was Ms. Hardy even working on a simple FOIA request and electing to respond then to the requester rather than simply waiting until the next morning? More intriguingly, why, after that near midnight hour transmission to the requester by email, did the White House begin to adopt a radio silence posture, going completely dark, with no further communication about a request that should, under the FOIA, trigger a response in as little as 20 days, or within just 10 days, should some unusual circumstances happen to arise? Why would it take 9 months of planning, 2 years of searching before the requester heard anything back from the White House after beginning 3 rounds of litigation in federal courts just to obtain some response? And that is a question now, some 5 years later, on petition for certiorari at the Supreme Court. Control, this is Echo 5 break, and we have a visual come back. Over. Stand by, Echo 5. Over. Roger, over. Proceed, Echo 5. Over. Control, we have identified bogey. Break. We can confirm on visual observation in a breach of the perimeter of Sector 6. Break. The bogey appears to be attempting to infiltrate and exploit a restricted area, storing classified information. Break. The unauthorized disclosure of which, break, could reasonably be expected at least to cause damage to national security. Break. What do you advise, Control? Over. Stand by, Echo 5. Over. Roger, Control. Over. QIF, this is Control. Break. Higher command is recommending that you approach with caution and attempt to contain and deter the bogey, disrupting its current infiltration effort. Break. Use of force is at your discretion, Echo 5. Break. Your mission objective is to defeat the threat and report back with updates on your progress. Copy, Echo 5. Over. Copy, Control. Defeat at discretion and report back, Control. Over. Good copy, Echo 5. Out. The FOIA, or Freedom of Information Act, provides only 9 exemptions from its disclosure requirement. And in keeping with the policy of full disclosure, the exemptions are narrowly construed with doubts resolved in favor of disclosure. There is a presumption of disclosure. It is clear that the FOIA contemplates that the courts will resolve fundamental issues in contested cases on the basis of in-camera or in-court examinations of the relevant documents. Hence, an agency must present a public affidavit or declaration explaining in as much detail as is possible the basis for its claim that it can neither confirm nor deny the existence of requested records. When, however, issuing a GLOMAR response, the test is whether the agency's judgment objectively survives the test of reasonableness, good faith, specificity, and plausibility. A priori, when using it to answer a FOIA request in most ministerial obligation, an agency must tether its GLOMAR response, neither confirming nor denying, to at least one of the statutory FOIA exemptions that are authorized. However, a GLOMAR response may be defeated by an official acknowledgement from the government. An official acknowledgement must meet 3 criteria, and the specific information sought by the plaintiff must already be in the public domain by official disclosure. Control, this is Echo 5, over. Echo 5, this is Control, over. Control, we have a positive visual on the bogey, break. We have attempted to contain and disrupt the infiltration, break. We have attempted to channel the bogey under the hard deck to provide a buffer between this activity and the more restricted areas above the ceiling, break. However, Control, the bogey has evaded our efforts and persisted in its infiltration and exploitation after achieving a breach, break. What do you advise, Control? Over. Stand by, Echo 5. Over. Bounty Control. Standing by. Over. Intruder, hold your activities now. Security forces have arrived in your sector and have you under close observation. Resistance is futile. Please surrender or they shall be compelled to take appropriate actions with extreme discretion. This is your final warning. By October 2020, 8 months into the COVID-19 pandemic declaration, Judicial Watch and the Daily Caller had begun to utilize the FOIA for essentially phishing expeditions, mainly to target Dr. Anthony Fauci, the director of NIAID, and had received in 2020 as many as 300 emails. And the search for a smoking gun email had begun. By June 2021, BuzzFeed had obtained over 3,200 pages of emails connected to Dr. Fauci, while reporters at the Washington Post had obtained 866 pages of emails, also on a phishing expedition, but in their case to vindicate a man who they had portrayed as under siege by the Trump administration that had been at least outwardly balking against his efforts to implement policy and guidance during a global public health crisis. The who and the what fascinate people, but the real question most open is why. However, this request for agency records, acknowledged as received by the White House on March 23, 2021, near the midnight hour, had been very different in character from these other fishing expeditions. It was not a typical request seeking any and all documents, but rather a targeted request for at most 2 specific documents, probably no more than a page each, and not seeking to add to the conversation about the who and the what, or even the how. Rather, this request for agency records had been craftily designed to provoke a specific response from the government, relying upon those 9 exemptions authorized for use by government agencies to justify withholding of agency records under various justifications, to include privacy interests, ongoing law enforcement investigations, matters prohibited from disclosure by law, and of course matters that have been classified for reasons of national security. Working in close association with the Director of National Intelligence, or DNI, who holds authority to classify information up to the level of top secret, the only persons who possess original classification authority at the White House are the President himself, the National Security Advisor, and the Chief of Staff. And under executive order, if any information is classified, an original classification authority, or OCA, either the President himself or persons with delegated authority under him must render that determination and provide on paper an agency record, a concise justification as to why that information warrants classification of confidential, secret, or top secret. These controlling rules dictate that basic scientific research data, like in this case infectious dose or the specific amount of SARS-CoV-2 particles that must be transmitted to a host, to achieve an infection for COVID-19 could not be classified unless this information was directly related to national security, defined as foreign affairs and military forces. In an official acknowledgement by the government on May 7, 2021, 2 months after the White House had received this request for agency records, the CDC had publicly conceded that the infectious dose of SARS-CoV-2 needed to transmit infection had not yet been established, nor to date has that number been established. This is not a difficult epidemiological metric for assessment of transmissibility risk to determine, and science has known how well to perform this procedure since the end of the 19th century. And yet, for some unknown and unarticulated reasons, this basic scientific metric had not been determined and has not been determined, nor made a priority for determining by the government during a pandemic in which a virus had beat Hitler in half the time in fatalities. Not by either the president nor by Dr. Fauci was this made a priority. And America, even today, since April 4th, 2020, has led the world in fatalities. However, if this metric had been classified under the controlling executive order, the government would, by operation of law, have to own or control this virus. This was the document being sought to establish ownership. And after dispatching a brief email near midnight on March 23rd, 2021, the White House had elected a right to remain silent, a matter now, once again, before the Supreme Court. Control, is Echo 5, over. Echo 5, this is Control, over. Control, the bogey has penetrated the hard deck ceiling and is continuing to infiltrate the restricted area. Break. Please advise, over. Stand by, Echo 5, over. Roger, Control. Standing by, over. Intruder, halt your activities now. Security forces have you under close observation. Resistance is futile. Please surrender or they shall be compelled to take appropriate actions with extreme discretion. This is your final warning. According to the Federal District Court in Richmond on July 7, 2021, the pro se plaintiff had filed inter alia a petition for declaratory relief in a matter brought under the FOIA, a matter granted priority of civil action, in which that court possesses most competent jurisdiction to enjoin the agency from withholding agency records and to order production, even an agency as lofty as the White House. However, that did not occur. On August 23rd, 2021, touting a vaccine that had been known as Pfizer-BioNTech COVID-19 vaccine and now marketed as Comirnaty for the prevention of COVID-19 disease in individuals 16 years of age and older, had been granted full approval for private label marketing by the FDA. However, for purposes of fraudulent concealment, if the management knows that certain facts will necessarily prevent the regulatory approval of a product and conceals these facts from the investing public, then there is scienter, which would pierce the veil of immunity provided to pharmaceutical companies under the PrEP Act during the pandemic and the development and distribution of what had been termed as medical countermeasures against COVID-19. In appraising the sufficiency of the complaint, federal district courts follow the accepted rule that a complaint should not be dismissed for failure to state a claim unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. To conflate the standards of frivolousness and failure to state a claim would thus deny especially indigent plaintiffs the practical protections of access to the courts. federal court in D.C. on the third litigation in which this claim had been brought, had conceded to acknowledge that the White House did and continues to refuse to reply in any manner to the FOIA request, asserting a presumptive claim of executive privilege. This is a legal term of art that has, since the Watergate scandal, resulted in a court compelling a response from the White House. However, with FOIA number 21220, the situation had most abruptly changed. Under the Code of Federal Regulations, the Solicitor General is responsible for determining whether appeals will be taken by the government, as well as assisting the Attorney General in the development of broad department program policy. To satisfy the threshold of an official acknowledgement, the information requested must be as specific as the information previously released. It must match the information previously disclosed, and the information requested must already have been made public through an official and documented disclosure. Clearly, the specific information sought by the plaintiff must already be in the public domain by official disclosure. Most importantly here, with respect to OMB FOIA number 21-220, the Solicitor General, responsible for conducting all Supreme Court cases for the government in a court of record, the nation's highest court, on January 22nd, 2022, had expressly for the government waived its right to file a response in this case unless requested by the Supreme Court. A GLOMAR response, neither confirming nor denying the existence of an agency record, albeit not tethered as required to any lawful exemption from disclosure. This would reasonably suggest a record that the government has officially acknowledged information, and a FOIA plaintiff may, under the law, compel disclosure of that information, even over the agency's fiercest valid exemption claims. Where a party does not challenge that determination, any challenge to those determinations has been waived. Intruder, this is your final warning. Resistance is futile. Please surrender or they shall be compelled to take appropriate actions with extreme discretion. This is your final warning. Working in close association with the Director of National Intelligence, or DNI, who holds the authority to classify information up to the level of top secret, the only persons who possess original classification authority at the White House are the President, the National Security Advisor, and the Chief of Staff. OMB FOIA number 21-220 had requested the agency record required to classify information by an original classification authority, which could be the President or any agency head to whom he has delegated this authority. This document request had sought information about basic scientific research information, specifically infectious dose and or secondary attack rate for COVID-19, which by executive order cannot be lawfully classified unless it is directly related to national security. Infectious dose and secondary attack rate are standard metrics for assessment of transmissibility risk. However, to date, both of these metrics remain officially unknown, which sounds like it is classified. Under executive order, the government can only classify information that it either owns or controls, and these metrics might only be properly classified if the novel virus was, in fact, a weapons system. On February 4th, 2020, and again on March 27, 2020, the former HHS Secretary Alex Azar had determined for purposes of issuing emergency use authorizations for both the PCR tests and COVID-19 countermeasures or vaccines, had determined that the novel virus was a CBRN agent or agents, i.e., a biological weapon. This description appears in all of the submissions by the pharmaceutical companies as well. Although this is publicly available information, as as a law enacted by Congress. Most Americans, however, are not aware that the HHS secretary had told everyone in February 2020, after the virus had established footholds in 23 nations outside China, leaving a Milei massacre death toll behind in its wake, had designated the pandemic not as a highly contagious disease spreading around, but as a biological weapon attack. Ignorance of the law is no excuse. And adopting a containment strategy to limit damage, Dion Hardy at the White House had a pressing situation when this request for documents had arrived in March of 2021, especially before the first COVID-19 vaccines had been approved for private label marketing by the FDA on August 23rd, 2021. Yet according to a sworn declaration from the former Deputy General Counsel for the White House, Heather B. Walsh, OMB had decided at first to limit exposure, interpreting the request as seeking only evidence that this biological weapon had been classified as confidential, commencing then a 2-year search on unclassified and classified emails after 9 months of consultation with the National Security Council. This search strategy had effectively shielded from discovery any residual traces of evidence of classification by setting these search parameters sufficiently low with a hard net control established at the level of classification, limiting this search, even on classified systems, only to that which is confidential or below. However, by definition, information about a weapon system would automatically warrant a classification of at least secret, if not top secret, with additional document control measures normally required in a sensitive compartmented information facility, or SCIF. And to date, now on petition for certiorari at the Supreme Court in a recent action, both the Federal District Court and the Circuit Court of Appeals in Washington have approved what have been termed as a good faith effort to locate the requested documents in a reasonably calculated search, a 2-year search for classified documents limited to the confidential level on email for documents that, if they exist, should be located not on email but in a restricted access safe in a SCIF. Mr. Bond, I must commend you. You have far exceeded even the stories of your previous exploits. And this time, you actually almost got away with your rather perfect operation. However, most unfortunately, our security forces had recovered your confidential weapon system. Too bad, Mr. Bond. This job is to be yours for you. You are a very smart man, Professor. Indeed, Mr. Bond. I went to mock school. A very special mock school where we had learned all about novel coronaviruses. And this one has been acknowledged in, shall we say, discreet circles to possess an etiology rather quite singular.
The most famous sentence Howard Baker ever uttered was his immortal line about Watergate. What did the president know, and when did he know it? The inquiry ends there.
This message was approved by Major Mike Webb. Honest.